it's a little after 7, so I think we'll get started with Jason. And we're also Zooming the meeting, okay? So that's, well, I guess you don't need to know that. Anyway, I talked about all of the accomplishments of Jason and Steve in our email. And Jason's been here twice before, I think. And he's always wonderful. He's been an English teacher in another life, so that's one of the things I think that makes him engaging, because he had to keep students engaged. And he always has such wonderful insights about the Supreme Court. And so I'm really pleased because the session finished to have him here tonight. And I thank you all for coming. And thank you all for joining, those of you that joined. And if you haven't, I'm not asking people a lot to do it anymore, but I still am very grateful for all of you that have. So thank you all, and we will have a meeting next month. It hasn't been set who will come yet, but we will have someone. And then again in October, we'll have Chris Collins, who was he was head of the elections office in Houston. He was very innovative and with 24-hour voting and all kinds of things. And then in November, we will have Joe Jaworski, who's running for Attorney General. So we kind of actually have a schedule filled out, which is great. So I would like you to welcome Jason, and he will tell us what's happening at the top of the pile here.
All right, thank you for having me. I hope it's okay. I came a little dressed down, so I'm still transitioning into like going out in the world again. I'm not ready to put a suit on yet. So they want me to use the microphone for the Zoom here, and I feel a little bit like a stand-up comic or something. So I'll try not to speak too loud or be consistent with where I'm holding this. We're going to talk about the Supreme Court, not just this past term, but also kind of try to situate what's going on at the court right now in a broader historical context. So we're going to start, and I apologize, the screen's not huge, so some of this type might not be big enough for those who are in the back, but it's actually, it's as much for me as for anybody else, just to keep me on track. But we're going to talk about the new Roberts Court, and to start, to talk about the new Roberts Court, we need to start with the Warren Court. And most of you are probably familiar with the Warren Court, 50s and 60s. The Warren Court consistently had at least 5, most often 6, and sometimes 7 liberal votes on the Warren Court, depending on what year you're talking about, and depending on how you count liberal versus conservative. But the bottom line is the Warren Court was a very solidly liberal court. Nixon got elected in 1968, and before he got elected, Chief Justice Earl Warren stepped down to try to give LBJ the opportunity to appoint his replacement before the election. And then a bunch of stuff happened, and that LBJ wasn't able to do that before leaving office. Nixon came in and immediately had the vacancy that Warren had left open, and a bunch of other stuff happened, including a couple of deaths. And within 2 years, his first 2 years in office, Nixon had 4 vacancies on the court. So the Warren Court went very quickly from being a solidly liberal court to now it's the Burger Court, and it's a not solidly conservative, but a tilting conservative court with the Burger Court after Nixon came into office. What we got with the Burger Court and Nixon's justices is we got this emergence of what we call a swing justice, right? So it was tilting conservative. Justice Powell he sort of emerged in the 1970s as the swing justice. So the court kind of was fairly balanced between the liberals and the conservatives, tilting a little bit conservative, Lewis Powell being the one in the middle, and the swing justice who would swing back and forth depending on the issue and that sort of thing. In 1980, I think it's 81 maybe, is when Justice O'Connor is appointed to the court. She becomes the new swing justice. She displaces Powell. She's a little more conservative than Powell was, so the center of the court sort of shifts a little bit rightward under O'Connor as the new swing justice. And then later when O'Connor leaves the court in, I think, 2001-ish, maybe, Justice Kennedy becomes the new swing justice, and he's a little more conservative than O'Connor. So we went from Powell to O'Connor to Kennedy as the middle justice, and the center of the court was shifting rightward with each one of those changes because the new swing justice was a little more conservative than the last one. And that's the era of the swing justice, basically going from with the Berger court and into the Rehnquist court from Nixon to Bush Jr. In 2016, many of you will recall, Justice Scalia died. President Obama tried to appoint Merrick Garland to replace Justice Scalia. We had a balanced court with 4 staunch conservatives, 4 center-left liberals, and then Justice Kennedy in the middle as the swing justice. And he would vote about 60% of the time with the conservatives and about 40% of the time with the liberals, just depending on the issue. So again, tilting conservative, but in the middle. And when Justice Scalia died, had Obama been able to appoint Garland, that would have shifted the balance, because with 4 staunch conservatives plus Kennedy, the conservatives often had 5 votes. With Scalia gone, if Garland had taken Scalia's place, the liberals then would have had 5 sort of center-left liberal justices. The new swing justice probably would have been Justice Breyer. He's the liberal justice who's closest to the middle. So we had this sort of opportunity to have a tilting left court with maybe Justice Breyer as the new swing justice. And then, of course, as you all know, the Republicans blocked Garland from being confirmed to the court. The orange one was elected, and he appointed Justice Gorsuch to take Justice Scalia's place. That didn't shift the balance of the court. Justice Gorsuch is actually very similar to Justice Scalia in a lot of ways. So it didn't change the balance of the court, but what it did is it foreclosed that opportunity to have a left-leaning court for the first time in 40 years, 45 years, I don't know, however many years. So instead of getting Garland, we get Gorsuch, and instead of getting Breyer as the swing, maybe the new swing justice, we stick with Kennedy. And then what happens is in 2018, Justice Kennedy retires, and President Trump appoints Brett Kavanaugh. Kavanaugh is not like Kennedy at all. Kavanaugh is very much a staunch conservative. He's a lot like Chief Justice Roberts. He's very similar to Chief Justice Roberts. And the two of them, they are very staunch conservatives. They're not crazy like right-wing conservatives the way, like, say, Justice Thomas might be. But they're very staunch conservatives. So Kavanaugh replaces Kennedy, and that makes it we no longer have a swing justice now. We've got 5 staunch conservatives on the court. They've got a solid 5 majority. The middle justice becomes probably Chief Justice Roberts, and he's not a swinger. He votes with the conservatives like 92% of the time. And then, of course, last year, Justice Ginsburg passed away, and President Trump appointed Justice Barrett, Amy Coney Barrett. This changes everything because now instead of 5 staunch conservatives on the court, we now have 6 staunch conservatives on the court, like very strong conservatives. This basically makes the new Roberts Court like the Warren Court, but for the right. So the Warren Court was really well known for these robust liberal decisions, protecting civil rights, criminal defendants, all that kind of stuff. The new Roberts Court really is poised to be the Warren Court for the right. We've just had 1 term now with that 6 justice majority, but we're already starting to see a little bit of this peeking through, which we'll get to in a second. But what it remains to be seen, like exactly what is going to happen this way. But it's for the foreseeable future, because the 3 justices who are the oldest and most likely to leave the court anytime soon, Justice Breyer is the oldest right now and the most likely to leave next. He will hopefully leave while President Biden is in office. it's not guaranteed, however. Similar to Justice Ginsburg, who held on and then thought she could continue to hold on through the first term of Trump presidency. Breyer's kind of got a similar attitude, and he may just hold on as long as he can hold on. And if he does that and then isn't able to hold on, and Biden's not reelected, then we could see another conservative justice replace Justice Breyer, which would put us into seven conservative justices territory, which again would be like as strong as the Warren Court ever was for the left, only now for the right. The other two justices who are getting up there in age are Justice Thomas and Justice Alito.
So, why would he avoid
Retiring?
Retiring during a time when there's at least a chance to have.
Like Justice Ginsburg and Justice Breyer both sort of had the attitude that like we're not trying to game the system or anything like that. I'm going to do the job as long as I feel like I'm capable of doing it. Of course, I'd prefer a Democratic president to appoint my replacement, but I'm not trying to play games with my seat. I'm just going to do my job as long as I can do it until I feel like I need to go. And that's what Ginsburg's attitude was, and then she passed away before she got to choose whether or not to leave. And Justice Breyer kind of has a similar attitude. So some people think, of course, he's going to retire probably after this term, like in other words, next spring. Other people are not so sure about that because of his attitude about, hey, I feel pretty good. I feel like I can do this job for a while longer. So we don't know. Some people thought he might retire this spring. Once Biden was elected, that he might, at the end of this term, he might just announce his retirement. That didn't happen. So the most likely time would be next spring, but we don't know. We'll see what he does.
I know it seems that Republican appointed justices retire very strategically.
Yeah. So a long history of the Republican Party taking the courts more seriously than the Democratic Party. A long history of that. They've been more strategic about the way they retire. They've been more strategic about who they appoint. The Democrats aren't appointing hard left 30-year-olds to the federal courts. The Republicans are appointing hard right 30-year-olds to the federal courts every chance they get. The Republicans have taken the courts more seriously than the Democrats ever since the Warren Court, basically. Nixon in '68, Nixon ran against the Warren Court, lambasting the court for being this, the liberal Supreme Court. And ever since then, the Republicans have been more serious about the courts than the Democrats. And that's just how it's been.
Yeah, I wonder why is that? I mean, Democrats should play just as hard as the Republicans.
Well, we're getting off a little bit on tangent, but the Republicans made the court an issue through Nixon and the Warren Court, right? And so the Republicans saw the court as an enemy when the Warren Court was issuing liberal decisions. The Republicans sort of cast the court as an enemy and made the court an issue, and then continued to make the court an issue. And they've, by the way, they've cast the court as the liberal Supreme Court, and they've made the court an issue for 45, 50 years, even when the court has been a conservative court. They continue to call it the liberal Supreme Court. Justice Kennedy swings over to vote with the liberals to recognize the right to same-sex marriage, and it's the liberal Supreme Court, and we have to, the Republicans campaign on that incessantly, even though Kennedy's voting with the conservatives 65% of the time. So it's just a difference in the way the parties approach the courts, and until we change that, it's going to continue to be that way. Biden, by the way, one note of hope: President Biden has been way more active in appointing judges than I think any past Democratic president in since maybe LBJ.
Doing more work than Trump.
He has appointed more judges in the time he's been in office than any president has. He's been quicker to do that than any president in the last 30 years or something. So Biden's very active. He's very up on the courts. He's got good people advising him. That's a sign of hope. But the party-wide, the Democrats still need to do more to focus on the courts.
There's no left in the equivalent of the federal.
There's the American Constitution Society, which is sort of the left-leaning equivalent to the Federalist Society, but they're not as robust and active as the Federalist Society is. Thomas and Alito are the other two that are getting up there. They're not going to retire under a Democratic president. They would have to leave involuntarily, and neither of them is that old or that frail. It's not going to happen in the first Biden term. Maybe in a second Biden term, you know, there might be some outside chance that one of them might retire or health, you know, issues might develop or something like that. But really, there's not a lot of opening on the court anytime soon. We have the new Roberts Court for the foreseeable future. And unless we keep electing Democratic presidents or we do something else, there's a lot of talk about court reform, adding seats to the court, creating term limits. You know, there's lots of different options for court reform. That's really the only other option, unless you just elect Democratic presidents until, you know, some of the conservative justices have to leave or something like that. Otherwise, for the next whoever knows how long, we've got a very strong conservative majority on the court. All right, as far as this last term goes, this is another thing to put in historical context. The court decided 64 cases on the merits this last term, plus 5 more summary reversals, which means rather than hearing the whole case on the merits, they just summarily reverse the case. So that's a total of 69 cases that were decided by the court
In what period of time?
this last term.
Okay.
Yeah. So in historical context, the court used to decide 150 to 200 cases per year up until the early 80s. Regularly 150, often pushing 200. In the mid 80s, Chief Justice Rehnquist, and this goes along with the sort of conservative mindset that the court should do less. The Chief Justice Rehnquist brought that number down to about 100 cases per term. And it hovered around 100 cases per term for 20, 25 years, something like that. When Chief Justice Roberts took over, that number started dropping down first into the 90s. Well, Rehnquist might have gotten it down into the 90s, but it was down steadily in the 90s and then into the 80s. And pretty soon we were hovering around 75 or 80 cases per term. For the last, I think it's 3 or 4 terms now, we've been under 70 cases. So the court is doing very little. 69 cases, the lowest number since the Civil War, I think, was not this last term, but the term before that. And then this last term, it ticked up by a couple cases. But they are now, over the last several years, deciding under 70 cases per term. They get about 8,000 to 10,000 petitions every year. So when you're deciding 70 or fewer cases out of 8,000 to 10,000 petitions, you're deciding, I mean, it's less than 1% of the petitions.
Are they taking different kinds of cases than they would have traditionally?
No, it's the same kind of mix of cases, but they just do less. And so it takes 4 justices to grant a petition, but the 3 liberals are now not going to grant any petitions that they would like to. In any case that the liberals would like to address, they're not going to take because they can't get a majority to address it the way they want to. We might see, now that there are 6 conservatives, we might see an uptick a little bit in the number of cases they take because they can be confident that they can do it their way if they want to. But with the swing justice over the last decade, the liberals have been nervous because they can't guarantee Kennedy would go their way. And the conservatives sometimes were a little nervous because they couldn't guarantee Kennedy would go their way. Once they got their 5 justices, they can be selective and take what they want. They also, like I said, the conservative mentality about the court is that it should just do less anyway. So we might see the numbers stay low because the conservatives on the court just don't want to do a lot. Or we might see it start to tick up because the conservatives feel like they could do whatever they want and they'll take more cases. We just don't know yet.
So the number of cases that are presented for petition, has that also been climbing?
No, that's been pretty steady for a long time. When I say 8,000 to 10,000 petitions, that's a pretty big range, right? That's a 2,000 petition range. It sort of ebbs and flows within that 8,000 to 10,000 range. That's been pretty consistent for a long time, and that just has to do
Not
with.
like they're just saying, hey, there's a lot of frivolous stuff out here.
Well, there is a lot of frivolous stuff. Yeah, I mean, out of those 8,000 to 10,000 petitions. I'm making this number up, but I would not be surprised if it's like, 4,000 or 5,000 of them really have no business being at the court, right? But still, even if you say that you cut those as being frivolous, if you've got, say, 4,000 petitions that actually have some merit, and they're still only taking 70 cases out of 4,000 petitions, that's not a lot, right?
And so are they taking topics, so to speak?
They take it case by case.
Maybe they have multiple opportunities to try kind of the same thing. And that, you know, like Jane has something that she's trying to get on the Supreme Court. Charlie hasn't.
So one of the things, yeah, I mean, one of the things that goes into their decision making when it comes to which cases to take is they want what's known as a clean vehicle. So they might get 40 petitions that are addressing a certain issue, a legal issue, but 28 of those 40 petitions, they have other issues in them, and they want a case that isn't polluted with other issues, right? They want cases that are clean vehicles to decide 1 or 2 or maybe 3 issues, but they want it to be clean like that. So that actually is not an ideological problem. That's just a litigation problem. Cases typically have many issues in them, and so it's hard to get a case that is really clean with just 1 or 2 issues that need to be decided. So that's one thing that weeds out a lot of cases, and they are looking, you know, the justices on the court, especially some of the hardliner conservatives, they're looking for particular issues. They're on a mission, right? There are certain issues where they're really looking for certain things to do, but they're looking for the right case to do it in. They want a good, clean case where they can do the thing they want to do and not have it get muddied up. All right. We did see over the last term, Justice Kavanaugh, BK stands for Brett Kavanaugh, he is sort of emerged maybe as the middle justice. That doesn't mean a lot when you have 6 in the majority. A middle justice we don't really have we don't have a swing justice anymore. But we might be able to sort of see where the middle of the court is and see like, okay, like who are the 3 liberal justices now need 2 conservative justices to join them if they ever want to win anything. So trying to figure out where the middle of the court is and who are the 2 justices most likely to swing over with the liberals, it's probably Chief Justice Roberts and Justice Kavanaugh. The 2 of them are very similar. They're both, on today's court, they are both probably closest to the middle. That doesn't mean that they are swing justices. It just means they're not as far right as the other justices.
More institutional.
Justice Roberts is sort of seen that way. That's his reputation, that he cares about the institution and that sort of thing. I will throw out there, though, that Justice Gorsuch also, again, he's a lot like Scalia, and every once in a while on certain issues, Scalia would join the liberals, especially if he could make some originalist case for why he should be doing that. Gorsuch is similar to that. Gorsuch sided with the liberals, not this last term, but the term before in a big Indian rights case. He has also on like Fourth Amendment cases or other things like that, he'll sometimes take a position that, like Scalia, surprises the conservatives. So I would say Roberts, Kavanaugh, and Gorsuch are probably the 3 justices that the liberals have the best chance of getting, but they're not going to get them very often. One way that we know this is for the last 10 or 12 years, there's very consistently been about 25% of the decisions have been 5-4 decisions. So about a fourth of the court's docket is split on that 5-4 line, with the swing justice going one way or the other. This last term, only 15% of the decisions were 5-4. So we got a drop in the number of splits like that. But another 10% were 6-3, with the 6 conservatives on one side and the 3 liberals on the other side. So that split that we used to see with the swing justice, it's shifted over now where we don't get 5-4, now we get 6-3. So the 25% that we used to have, it's now 15-10. So that's some signal of what direction we're headed. We're going to see probably fewer 5-4 decisions because the conservatives will all vote together on a lot of cases that normally would split 5-4, but now they're going to split 6-3. All right, moving on to actual cases from this last term. So not last year, but the year before, there was a case called Ramos, and there's a Sixth Amendment right in federal court to have a unanimous jury. So we're going to talk. This is the beginning of starting to look at what this new court, the new Roberts Court, looks like. Under the Sixth Amendment in federal court, if you're a criminal defendant, you have the right to a unanimous jury. You cannot be convicted by a 10-2 verdict. It has to be unanimous. The question in the Ramos case was, does that apply in state court? Does the federal Sixth Amendment right apply in state court where you have to have a unanimous jury? And there were two states, Louisiana and I think it was Oregon, were the two states where under state law you did not have to have a unanimous jury. So you had a lot of criminal defendants who were convicted, I don't know if it's a lot, but some number of criminal defendants who were convicted with a non-unanimous jury. And eventually, this guy named Ramos challenged that and said, hey, I have a Sixth Amendment right to a unanimous jury if I'm in federal court. That ought to apply in state court if it's a federal right. And in the Ramos case, the court decided, yes, you do have a Sixth Amendment right to a unanimous jury. It does apply in state court. Well, there's this thing about when the court recognizes a right, it then has to decide whether that right is retroactive. Okay, so what happened is after Ramos was decided, not last year, but the year before, a whole bunch of prisoners who've been convicted on non-unanimous juries filed petitions saying, hey, if I had a right to a unanimous jury, I shouldn't be here. So in the Edwards case, which came up this last term, the court had to decide, okay, is the right that we recognize in Ramos, is it a retroactive right? Or is it just going forward? And the way that they decide that is it has to do with whether the right is a substantive right or a procedural right. If it's a substantive right, then that right theoretically existed from all time and eternity, from the beginning of the Constitution onward, a substantive right was always there. So if it's a substantive right, then it's retroactive. If it's just a procedural right, well, procedures change. And maybe we didn't recognize that right procedurally before, but we recognize that right procedurally now. But since it's just a procedural right, it's just going forward. It's not retroactive. So obviously, for the criminal defendants who are in prison and were convicted by non-unanimous juries, they'd like that to be a substantive right, because if I always had that right, I shouldn't have gotten convicted. What the court said this in the Edwards case, deciding the retroactivity, is the question is Ramos retroactive? And the court said 6-3, no, it's not retroactive. Justice Kavanaugh wrote the opinion for the 6 conservatives, and they all agreed this is just procedural. The 3 liberals dissented, said, are you kidding me? We recognize these kind of rights all the time as being substantive rights. Whether or not you get convicted under the Sixth Amendment by a non-unanimous jury is a substantive right. Conservatives said no. So all the prisoners who are in prison convicted by non-unanimous juries, their petitions are all going to be denied now, and they're in prison and they're stuck. So that's a hint in the criminal law context of where the new Roberts Court is going to go with some things. Okay, the next thing we're going to talk about is standing. Anybody know what standing is? Some of you kind of. Okay, so Article 3 of the Constitution, which is Article 3 is the article that creates the federal courts, the judiciary, right? It says that the courts, the judicial branch, will be empowered to handle cases and controversies. That's the phrase, case or controversy. So the court over the years, going back a century and a half or whatever, started to develop this doctrine that says in order for the court to have jurisdiction over your case, because we only have jurisdiction over cases and controversies, it has to be a real controversy. And the only way for it to be a real controversy is you've got to have a real injury. And if you don't have some real injury, some real harm that you're suffered, then you don't have a real case. And the word that they started to use for that is standing. You don't have standing to bring your lawsuit if you don't have a real harm or a real injury. The standing doctrine over the last, basically starting with under Chief Justice Rehnquist, it became one of those doctrines where the conservatives on the court have used standing as a way to narrow the cases that can actually get before a court. In other words, if we raise the bar for what it takes to have standing to bring a case, it's harder for you to bring a case. And if it's harder for you to bring a case, then the courts don't have to do so much, and we don't have to decide so much. And it also means like whatever you're complaining about, it tough, right? Because if the bar is high for standing, take your complaint somewhere else because you don't have standing to bring it to court. So the conservatives on the court have used the standing doctrine to basically close the courtroom doors to a lot of cases. This case is, I don't, Uzoig Bonham or something is how you pronounce it. I don't know how to pronounce it. But the question in this case, it was a First Amendment case. And the plaintiff was complaining about violation of First Amendment rights, but couldn't show any monetary harm, right? They hadn't lost any money. They weren't going to be sent to prison. They didn't have any kind of harm other than just, you violated my speech rights, right? You've just taken away my ability to speak freely. And there's no other harm. So the plaintiff, we sometimes in litigation will have what we call nominal damages. And nominal damages just means like, I'm asking for $1. But the point is, you wronged me and I'm suing you to vindicate my rights. And I don't have any other big damages, but nominal damages, I'm going to ask for nominal damages because that's all I got. Besides my right that I'm trying to protect, that's all I got. So the question in this case was, is that enough to have standing to bring this case? It is a nominal damages claim of $1 enough, or do you not have an injury that's serious enough to get into court? Now, this was a huge case. This is really important because if my First Amendment rights are violated and I don't have any harm other than my First Amendment rights were violated, but the court says you don't have standing, then that means there's a whole, and it wouldn't just be First Amendment, right? That's going to probably start to apply to other rights. So if all that you have is your right was violated, do you have enough of a harm to get into court? That was the question. A lot of people were worried about this. Fortunately, the court, 8-1, Justice Thomas wrote the opinion, says yes, nominal damages is enough if you have a violated right like this. Now, if you didn't have any constitutional right that was violated and your only harm was nominal damages of $1, that's another case, and we don't know what the court will say about that. But here, constitutional violation, that's enough. And we got almost the whole court to agree to that. The one justice who disagreed and dissented is Chief Justice Roberts. Even though he is maybe close to the center on a lot of stuff, he's also the one who's probably the most aggressive on the standing doctrine. He would like to see a lot fewer cases. He'd like to see the court deciding a lot fewer cases. He's possibly the most aggressive on standing doctrine, and he was the one lone dissenter saying, I don't think you have standing if you just have nominal damages.
If the government takes over my empty house and orders troops to me, I can still sue.
Well, yes, but if that happened, you have more than nominal damages because your house, right? Your
empty house, I'm not renting it.
Jason, could you repeat the question because the people in
First Amendment rights are regularly violated.
Yeah. So the question is for people listening on. The question is, if your right is violated, you do have standing. That's basically what you're asking. Yes, and the answer to that is
you're right.
That is yes, assuming it's a constitutional right. Now there are lots of other rights we have, statutory rights, things that we claim a right to, even though it's not in the Constitution. Those are going to be different cases, and we know we have at least one justice who would be likely to say, no, you don't have standing. We're talking about something else like that. I won't worry about the sequence. All right, personal jurisdiction is another one, another issue. So besides standing, you also can't get into court unless the court's got jurisdiction. And there are two kinds of jurisdiction. There's jurisdiction over the subject matter, and then there's jurisdiction over the parties in the case. So for example, a Texas state court has jurisdiction over a Texas resident, right? There's this doctrine called personal jurisdiction. It has to do with whether or not state courts have jurisdiction over non-residents, okay? Foreign defendants, people who aren't residents of the state. And it's another area where the conservatives on the court, again, to sort of narrow the number of cases that can get into court, they've used personal jurisdiction as a way to do that, raise the bar, make it harder to bring cases. So the way they do that is they have made it so that there are fewer situations in which a state court can exercise jurisdiction over non-resident defendants. And if they don't have jurisdiction, they can't hear the case. So for a long time, there's been this trend of narrowing personal jurisdiction, making it hard. And where this plays out, so this case is a tort case. It's a car. I think it's a defect case, car defect for Ford. But it would come up in all kinds of products liability situations or other tort situations where, let's say, you're driving through Nevada and you get into an accident and you come back home to Texas, and whoever you got in an accident with in Nevada sues, and they sue you in Nevada. And the question is, well, can the Nevada state court call you into the Nevada state court from Texas when you're a Texas resident? That gets really important when we're talking about corporations, right? And what corporations have done is they've argued, well, hey, I was a corporation incorporated in Delaware, and my principal offices, my principal place of doing business, my offices are in Atlanta. And since Delaware is where I was incorporated and Atlanta is where my principal offices are, the only places you can sue me are Delaware and Georgia. And so everybody who gets hurt by anything that corporation does in any other state can't sue them in their own home state because their argument is you don't have jurisdiction over me. And the conservative wing of the court has enabled corporations to make those kinds of arguments quite frequently because it makes it harder for plaintiffs' lawyers to sue for bad things corporations do. The Ford case was a big one because the argument here is it was a defect in the automobile. It actually arose in Minnesota, and I think the other case was Montana. So it came up in two states. But the people who, the plaintiffs who were harmed by these defects, they were residents of Montana and Minnesota. But the cars that had the defects, they had purchased the cars in other states, and the cars are made in other states. So Ford's argument was, hey, our principal place of doing business and the state in which we were incorporated was not Minnesota or Montana. And we didn't even make the car in either of those states. And you didn't even buy the car in either of those states. So we don't have enough contact with either of those states for you to sue us in those states. So the theory was the plaintiffs would have to travel to some other state to sue Ford for a defect that harmed them in their own home state where they lived. That was Ford's argument. And under a lot of case law, with the way that the conservative wing of the court has treated this, that was looking like that might be what they actually end up saying. So again, a lot of people paying attention to this case. Fortunately, the court unanimously says, no, no, no. In this case, Ford's advertising in Minnesota and Montana. They are selling this car there. It doesn't matter that the car that the plaintiffs happened to buy, they didn't buy there. Ford does sell that car in those states. And that was enough. That's good. Everyone on the plaintiff side of the docket sort of went, phew, good, glad that went that way. But it still leaves the door open for if you have other situations where here, Ford is selling that car in those states, even though these particular cars weren't bought there. But again, the door is still open for continuing to narrow this personal jurisdiction stuff and make it harder for plaintiffs to sue and make it easier for corporations to not get sued.
So in that case, they grant cert for the two cases.
Yeah, they were consolidated. Yeah. Okay, so by the way, if you notice, we actually had good news in those last two cases, right? In the personal jurisdiction case, everyone thought, the conservatives they're gonna hammer us on personal jurisdiction. They didn't. The other one was the standing. Conservatives are gonna hammer us. They didn't. So two areas of concern for those on the left side of things, worried about what the new conservative court was gonna do, and they didn't do it. And we got good news on both of those, on standing and personal jurisdiction. Moving to the Fourth Amendment. So this is a fun case. So in the Lang case, a guy was drunk and driving, but of course the police didn't know that. Unless you're weaving around, they don't have a way to know that you've been drinking. But he had his music up loud and he was honking his horn. And so he attracted the attention of a police officer. And the police officer started following him, and he drove home. He went all the way home, and into his garage. But before he pulled into his garage, he turned the overhead light on in his car. So the police officer pulled over, and as he was shutting his garage door, the police officer went into his garage, stopped the garage door from shutting, went into his garage, proceeded to talk to him, investigate further, finds out he's been drinking, arrests him, et cetera, et cetera. The defendant, Lang, says, hang on a sec. You entered my house, right? And normally to enter my house, you have to have a warrant, or you have to have permission, like I welcomed you in, or there has to be some other exception to my Fourth Amendment right against a search of my house, like something called exigent circumstances. So in Fourth Amendment law, when there are exigent circumstances, that means there's some kind of emergency situation that justifies the police entering the house without a warrant and without permission. Now, one example of that would be if the police have probable cause to think that there are drugs and things like that inside, and they also are hearing noises that gives them reason to think that the evidence is being destroyed inside, then that might create an exigent circumstance. For preserving that evidence is enough of an emergency situation where they can enter in without a warrant, without permission, and the Fourth Amendment doesn't protect against that. So the question in this case is, turning in this state, in California is a state, and in this state, turning your overhead light on in your car is a misdemeanor. You're not supposed to drive with the overhead light on in California. So the police officer said, I was pursuing a misdemeanor, a suspected misdemeanor, into the house. And pursuing a suspected misdemeanor is an exigent circumstance. In order to catch them, that's one of those exigent circumstances that gives me the right to enter the house without a warrant, without permission, because I'm in hot pursuit of the guy who turned his light on. Lang says, no, that doesn't work. So that's the question. Is pursuing a suspected misdemeanor an exigent circumstance to allow officers to enter your home? And again, a lot of worry about, wait a minute, conservatives on the court are going to let officers just enter your home if they think you littered or something like that. They didn't. Unanimously, in an opinion by Justice Kagan, they said, no, pursuing a suspected misdemeanor is not exigent circumstances, at least not all the time, not categorically. And the opinion basically says there might be certain situations, right, where maybe the nature of the misdemeanor creates exigent circumstances. Maybe there's a safety issue, and so the police who are chasing the suspected misdemeanor, they do have exigent circumstances in certain circumstances because of the facts in that case. But in this case, we don't have that, and it's not going to be categorically exigent circumstances. So the Fourth Amendment wins, and Lang, the officer's entry into the house is not allowed. Again, good news, right? A lot of people worried about what the new conservative majority on the court's going to do here, and we got good news. Part of the point of this is we don't know yet how the new Roberts Court is going to act. There are a lot of concerns, possibly legitimate, but so far maybe not, right? We might not have to worry about at least some of these kinds of issues. Another Fourth Amendment case. Fourth Amendment cases are sometimes just like the best. The facts are always fun. So in Torres, a woman's sitting in her car, and police show up and they approach her car, and she says she thought she was about to get carjacked. I don't know why she thought she was going to get carjacked by the police, but that's what she said. So the police started to approach her car, and she took off. She just drove off, and the police started shooting at her as she was driving away. They claimed they feared for their safety. So both sides are claiming some weird stuff here, right? Like she's claiming, I thought they were going to carjack me. They're police officers. They're probably not going to do that. The police are claiming our safety was at risk and we had to shoot guns at the fleeing person in the car. I don't know about that either. So those are the two stories. When they fire at her, they hit her a couple times, but she doesn't stop. she keeps driving. She actually drives 75 miles to a hospital. And once she checks herself into the hospital, then somehow the word gets to the cops and they show up and they arrest her. But she says this was an unlawful seizure, right? Under the Fourth Amendment. Fourth Amendment protects against unreasonable searches and seizures. When you are wrongfully arrested, that counts as an unlawful seizure. So she says shooting me was a seizure that violated the Fourth Amendment. And the police say, you got away, right? We didn't seize you. We failed to seize you. So the question in this case is, if police officers shoot at you and hit you, even though they failed to actually seize you, does it count as a seizure? The attempted seizure, does that count as the kind of seizure that the Fourth Amendment protects against? Now, the question about the reasonableness here is already sort of answered, because police officers cannot just start shooting at you because you ran, right? So it's already an unreasonable, if you just started running and they shot you and you dropped and they seized you, that's an unreasonable seizure, right? Because you can't just start shooting at someone who runs. But here she got away. And so they said, well, we didn't seize her. So no Fourth Amendment violation. So that's the question. Is the attempted seizure by gunshots, is that a seizure under the Fourth Amendment?
What were they like approaching her about to begin?
Can you repeat the question?
So the question is, what were they approaching her about in the first place? They were called to the scene. I'm not going to remember that. They were called to the scene to investigate something, and they just saw her sitting in the car with the car running. And so they were approaching her to ask questions about whatever it was they were called for. And I don't remember what the actual call was about.
And they were shooting at her.
When she drove off, they pulled their guns and started firing after her. And it might have been, I can't remember, but it might have been something where they had reason to think that whatever they were coming to investigate did have an element of potential violence to it. And so that's why they said they were afraid for their safety. I don't remember what they came. I don't remember what the nature of the call was that they were responding to. But it wasn't, hey, someone's sitting in her car with a car running. Like they weren't responding directly to her. She just was there when they showed up, and they went to.
More reason.
Yeah. Right. So this is the question, and the court 5-3. This is amazing to me that the court was split on this. It's 5-3, by the way. Justice Barrett did not participate. I don't know if you remember, but she did not get onto the court before the term started. So there were a handful of cases that she did not participate in. So it's 5-3 because Justice Barrett was not in it. Chief Justice Roberts and Justice Kavanaugh joined the three liberals to say this does count as a seizure under the Fourth Amendment. Just because she continues to run and gets away doesn't mean it's not a seizure, right? So again, good news. But the good news is getting a little bit sketchier now, right? Because it was 5-3. There were three justices who actually said, no, if she gets away, that's not a seizure. So you can fill her full of holes as much as you want, as long as she can still move. They don't seize her.
They approached her to serve a warrant. She was standing beside the car.
She hopped in the car.
And then she drove away.
Yeah. Were they serving the warrant on her?
On her.
Oh, it was. Okay. All right. So again, good news. This is a win for the Fourth Amendment, but barely. 5-3. Yeah.
Are there any justices who are other than 100% white?
Who are not white? Justice Thomas is African American. Justice Sotomayor is Latina. And I mean, I guess depending on. I mean, Jewish sometimes is counted as white, and sometimes an ethnic group that's not the same as white. So there's two Jewish justices. I don't know.
The rest are all Catholic?
Not Catholic.
They're not all Catholic. There are several Catholics. I don't remember offhand how
So that's
many of them are
six.
Catholic.
Six or seven.
Such as Episcopalian.
What's that?
I believe Gorsuch is Episcopalian.
Yeah, and I think Kavanaugh's. I don't think he's Catholic. Is he? Is he Catholic?
Yeah, he's
Okay. Okay.
It's predominantly Catholic.
Here it is.
It seems like such trivial
questions if you've got 10,000 other cases that are chomping at the bit to get in court?
Well, there.
Could you repeat that question?
So the question is that some of these issues seem like trivial issues if there are all these thousands of other cases that are there. Some of these might seem like really narrow. Trivial is not the word I would use, but I can see how it might seem trivial. But that's sort of the nature of the Supreme Court. The cases that get to the Supreme Court are cases that are addressing issues that really haven't been resolved. So that question has been sort of out there. It's come up in cases here and there, but it's never actually been answered. And so those are the cases that the court wants. The court wants to answer questions that need answering. There are a bunch of other what might seem like much bigger issues, but those have been decided. And so most of the work that happens in the country legally in the judicial system happens at the district courts and the circuit courts of appeals, because those issues over the past 200 years have been, most of the major issues have been decided. It's the narrow sort of marginal issues that haven't really been addressed. That's what makes it to the Supreme Court. And believe it or not, there are a lot of those. Especially the most common thing that you get at the Supreme Court is what they call a circuit split. So it's where you have an issue that hasn't been answered by the Supreme Court, but the circuit courts have answered it, but they've answered it differently. And so you have the circuit courts are split on a particular issue, and that's when the Supreme Court says, all right, I think we need to answer this so that we don't have different things happening in different parts of the country. That's your best, if you're trying to get a case at the Supreme Court, your best chance is to find an issue where the circuits are split on that issue. And then the court is more likely to want to answer that question. All right, moving to First Amendment stuff. So this is Philadelphia has a city ordinance that says for their social services and foster adoption programs and stuff like that, you can't discriminate against like same-sex couples and stuff like that. And there's I think it was a Catholic organization that wanted to be able to choose couples for the city basically used different organizations to facilitate its foster and adoption programs. And this Catholic organization wanted to be able to choose the couples that they placed kids with. And the way that they would do that is they would not place couples or place kids with same-sex couples. And the city says, can't do that. You know, we have a city ordinance that says you can't do that. So you're not going to be able to participate in this foster adoption program if you're going to discriminate based on same-sex couples. And so the religious organization sued and says that violates our right to free exercise under the First Amendment, right? Free exercise of religion. The Roberts Court has been extremely solicitous of free exercise claims, right? In other words, the Roberts Court likes to protect any kind of religious free exercise right that anyone is asserting in any way. Now, there's this old case called Smith. It was decided, I think, in the early 90s, 92, 93, somewhere in there. And Smith, Justice Scalia wrote the opinion in Smith, and Smith says, now Smith involved peyote, and Native Americans wanted, as part of their religious exercise, free exercise, they wanted to be able to smoke peyote in their religious practices. But of course, peyote was a criminalized drug. And so Justice Scalia said, hey, if you have a law that is written neutrally so that it applies to everybody equally, and it's not singling out a religion, then your religious free exercise right doesn't trump that law, because you're not being singled out for your exercise of religion. It's just a law that applies to everybody equally. And it's not about religion, it's just about an illegal drug. So Native Americans, you do not get to smoke peyote because it's a criminalized drug, and it's not written to target you and your religion. It's just written to apply to everybody. So free exercise rights under the First Amendment do not trump that. Smith's been around a long time. So in this case, the Catholic organization says this violates our free exercise rights by requiring us to not discriminate against same-sex couples. And the argument against that is, hey, this is a neutrally written non-discrimination law. It applies to everybody equally. We're not targeting your religion. We're just saying nobody who participates in this foster care adoption program can discriminate. So under Smith, you lose, and your free exercise rights don't trump this neutral law that applies to everybody equally. So the religious organization said, well, maybe the court needs to overrule Smith. So that's the question here. Is the organization's free exercise right violated, and does the court need to overrule Smith in order to reach that conclusion? The court says unanimously that this does violate free exercise. I'll let that sink in for a second. The 3 liberals joined the 6 conservatives to say that this neutrally written non-discrimination law violates the religious organization's free exercise rights. Unanimously, the court says that. But the court also says 6-3 that we don't have to revisit Smith. So, Smith says a neutrally written law that applies to everybody equally does not violate your free exercise rights. But the court unanimously says we don't have to revisit Smith, and yet this neutrally written law that applies to everybody equally does violate this religious organization's free exercise rights. Your guess is as good as mine how that works, but there might have been some horse trading going on. The liberals might have sided with the conservatives to say this does violate free exercise in order to get 3 of the conservatives to side with them that we don't have to revisit Smith.
Wasn't the basis it wasn't in the contract?
What's that?
That the prohibition on discrimination wasn't in the contract, it was a separate law that wasn't even mentioned in the
Can you repeat the
contract.
question?
The question is whether not discriminating was in a contract rather than a.
It was not in the contract with the charity.
Are you saying that that is the case, or you're asking me?
No, that's what I thought.
My understanding, without going back and reviewing the case again, my understanding is it's the city ordinance that's a question.
That's right.
Yeah, not a contract. It's not a contract issue, but just if it was a contract issue, I think it might have gone the other way if there was not anything in the contract. This is a city ordinance that says you cannot discriminate if you're going to participate in the program. And so the ruling that the court has is that the city ordinance is unconstitutional because it violates the religious organization's free exercise rights. So Smith still stands and might still be good in other situations and might still, allow laws to stand as neutrally applied. But in this situation, it doesn't, and the free exercise right wins out. So the non-discrimination law loses.
Wasn't there a case involving, this was like a long time ago, about involving free exercise, where it was, I think it was a youth call, where a Mormon group was saying that that polygamy was, that they believe that polygamy is a good thing, but then the court said that you can believe that, but you can't practice it.
Can you repeat that question?
Yeah, so the question is whether there was a free exercise case a while back involving a Mormon group, I assume a fundamentalist group that believed in polygamy still, and they were challenging laws against polygamy as violating free exercise. I'm sure that case has come up. My guess is that, and I don't know without looking at the case, my guess is that those challenges to the anti-polygamy laws failed under Smith, because the argument from Utah for the state of Utah would be these are nobody can practice polygamy. It's not targeting Mormons, it's targeting anybody. Nobody can have multiple spouses under our state marriage laws, and that just applies to everybody. So under Smith, your free exercise doesn't work.
Now the court ruled that you can believe that, but you can't practice.
Yeah, I mean, I don't know what specific case you're referring to. I mean, that's Scalia in Smith sort of said something like that, right? Like this might be part of your religion. It might be a legitimate religious belief, but we can't have legitimate religious beliefs, overturning laws left and right. If the law is written neutrally and it's not targeting religion, then the law is okay. That's what Smith said. Even if you believe it, it's fine if you believe it, but you might not be able to do that under this neutral law.
Reynolds versus United States, 1879. that what it was?
That's the original. Yeah, that's the original polygamy.
There were 3 of them since then, but they all go back.
Yeah.
Oh, this reminds me of 20 years ago, I heard some guy on the radio trying to argue that laws against same-sex marriage do not, he argued on technical grounds that they do not discriminate against gay people because he said that under the law, a straight person cannot marry someone of the same sex.
Yeah.
That was bizarre.
So that argument was made in the same-sex marriage cases. That argument and other arguments were made in the cases that, and ultimately that was why the laws were struck down, because the argument was if it's applying to straight or gay people, then what you actually have is gender discrimination. Or sex discrimination, right? Because then you're saying I can marry a woman, but I can't marry a man, so you're discriminating against the man I might marry based on his sex. So that argument backfired, basically. All right, so this is a bad news. And by the way, this is a way to point out that the liberals, the so-called liberals on the court, they are center-left, moderate liberals at best. We do not have Justice Brennan or a Justice Marshall on the court, and have not had a real like staunch left liberal justice for quite some time, a couple decades. All 3 of the remaining liberals are fairly centrist liberals on the court. They only look liberal compared to the 6 staunch conservatives who are on the court. But they will side in like a case like this. They will side with the conservatives on a lot of stuff. And this is weird. It's surprising that they could reach this outcome and not overturn Smith or revisit Smith, but they did it.
Do we have any idea how much behind the scenes negotiation goes on? Simply because even people who are not legal scholars, sometimes the outcome there, what are they thinking? So
yeah.
I mean,
So the question is whether or not we have any idea what goes on behind the scenes. Whether I suggested maybe there was some kind of horse trading going on with this case. That's pure speculation on my part. The Supreme Court is a black box. They are famous or infamous for not leaking stuff, and they have a lot of staff and clerks and people like that who. It's amazing that more doesn't leak. But we don't know. We don't know how much goes on behind the scenes. When a justice retires, a lot of times it's 20, 30 years before their papers are unsealed. So we don't find out till decades later any of the notes and, letters and memos back and forth that they had with other justices. We don't know. All we have is the opinions that get written, and the opinions explain the reasoning, and sometimes not very well. But that's what we get. We get their opinions, and that's all we get. We really have almost no insight into what goes on behind the scenes until usually years and years later. All right, another First Amendment case. This is the cheerleader case. You might have heard about this one. This is a cheerleader who she didn't make the varsity cheer squad, so she made a Snapchat where she used a particular finger and a particular word beginning with F and sort of said, F cheer, F the coach, F everything. And her Snapchat went to her, 200 followers that she had on Snapchat. And then it got back to the coach, the cheer coach, and she was disciplined. I think she was suspended and suspended from the cheer team, the JV team. Anyway, there's an old case called Tinker from the 1960s, which is, so it used to be, the old way of doing things is students had very little First Amendment speech rights. The argument was in the name of sort of, administrative order and control, teachers need to be able to keep order in the classroom and in the school, in the hallways. And so speech could be punished or stifled or curtailed or whatever in the name of discipline and keeping order in the schools. And that's just, we need to be able to do that. That was the old way of doing things. And then in the 60s with the Warren Court, we got some more protection for First Amendment rights for students. And the Tinker case was actually about some students, some high school students who were wearing black armbands in protest of the Vietnam War. And they were disciplined because the school said this is disruptive, it's creating problems in class. And the Supreme Court said, no. I mean, yeah, the school has an interest in maintaining order and stuff like that, but speech rights are important and students have a right to speak out. And if this is a matter of public interest and public importance, this war that's going on, they have a protected First Amendment right to speak out, even if it's in class. You know, if they're wearing a black armband in class, that's not so disrupt. They're not disrupting class with actual verbal speech. They're doing something that's quiet. It still counts as speech, but that's protected. So Tinker was a big case saying students actually do have some First Amendment rights. The question in this case was, does that Tinker protection for First Amendment rights for students, does that extend in this case where this is speech that in the classroom would have been disruptive and actually probably would not have been protected? Teachers can discipline you if you just burst out with the F word and start saying F cheer, F coaches, you know, all that kind of stuff. They actually can discipline you for that. You're not going to be protected by the First Amendment. So it probably is disruptive speech, but it occurred off campus. So the question is, what wins out here? Is it the students' First Amendment rights because this is off campus and outside the scope of what the administrators can control? Or is it the administration because this still was kind of disruptive? It got around to some of the other cheerleaders, it got around to the squad, it got around places, and that created some disruption. So what wins, the First Amendment or the administration's ability to control things? And the court, 8-1, says First Amendment wins, but there might be situations, it's going to depend on the facts, right? In this case, First Amendment wins because there wasn't really any evidence of any serious disruption, and there wasn't even that much evidence that many people saw it. Her 200 followers saw it, and it got back to the coach, but otherwise, there wasn't a lot of evidence that it caused that much disruption. But the court did say, you know, in other situations, the administration might be able to discipline things. So this is going to be an open-ended, especially, you know, with the internet these days and social media and stuff.
Wasn't that bong hits for Jesus?
That was on campus, though. That was a sign that was in.
Oh, it was.
It was. I think it was in like the football stadium. They held up a sign.
Just repeat what he asked.
The question was about the bong hits for Jesus case from several years ago. But what we do get is things. So what the court pointed out is there might be other situations where you have on campus, particularly internet speech, that the administration can discipline students for. For example, if you had situations of like, you know, serious cyberbullying going on, students, we might want administrators to be able to discipline that sort of stuff, right? Because that can be harmful and disruptive. So the court said that there are situations where First Amendment's not going to win, but here it does.
So which justice dissented in that case?
The justice who dissented was Justice Thomas, I think. What's that?
Isn't it Justice Breyer?
Yeah, the question is what the initials stand for. SGB is Stephen G. Breyer. Yeah, Justice Breyer wrote the opinion for the majority. All right, Eighth Amendment. So for a while, Justice Kennedy was sort of a champion of a couple things that where he would side with the liberals on some issues. Same-sex marriage is one of them, which we talked about. Another area where Justice Kennedy, as the swing justice, would side with the liberals quite frequently was in juvenile criminal cases. He's the one who sided with liberals to strike down the death penalty for juvenile defendants. So the worst that a juvenile defendant can get is life without parole. There's a couple other cases dealing with juvenile criminal defendants where he was protective of juvenile criminal defendants' rights. Justice Kavanaugh has now replaced Justice Kennedy. So this is one of the first big cases where juvenile criminal defendants' rights was coming up before the court. And there's sort of some question about, okay, what's going to look different now that Kennedy's gone and Kavanaugh is in his place? The question in this case, so again, juveniles can no longer be executed, but they can be sentenced to life without parole. And the question in this case was, before you sentence, the way it currently is in most states, before you sentence a juvenile defendant to life without parole, the judge has to consider the age of the defendant before imposing the sentence. The question was, does considering the youth or the age of the defendant, does that require an actual finding of some kind that the defendant is quote unquote incorrigible? In other words, in order to justify the life without parole sentence, that's what LWOP stands for, life without parole. In order to justify that sentence, does the judge need to make a finding that I think this defendant is incorrigible? In other words, they're not going to get rehabilitated, and because they're incorrigible, that's what justifies the life sentence. And the challenge to the sentence was, I think you need to make some kind of finding like that to justify the sentence. Otherwise, the sentence it violates the 8th Amendment against cruel and unusual punishment. If the sentence is not justified by some kind of finding like that, then it's a cruel and unusual sentence that should be unconstitutional. Now, with Justice Kennedy on the court, that probably would have been a winning argument. Question was, is it a winning argument with Kavanaugh? The answer is no. Kavanaugh and Barrett, once Justice Ginsburg was gone, there's now 6 justices who say no, as long as the judge considers the youth, the age of the defendant, and they say they considered the age of the defendant, then they can impose a life without parole sentence without any kind of finding that says they're incorrigible, or no kind of finding that justifies the sentence. Just, I considered the age of the defendant, and that's good enough. So that's a first hint at a shift in direction in the case law, with Kennedy gone and Kavanaugh and Barrett replacing Kennedy and Ginsburg. All right, I think this might be the last specific case we're going to talk about. Obamacare, the ACA, if you've paid any attention to the news, you know it's been challenged left and right by conservative organizations. They want to strike down the ACA in any way possible. Texas led a bunch of other red states, and what happened is when Chief Justice Roberts joined the liberals a few years ago to uphold the individual mandate. You remember this? There was this individual mandate in Obamacare that says you have to get insurance or you're going to pay this little fine. And Chief Justice Roberts joined the liberals and said that is not unconstitutional because it's a tax, and it falls under Congress's tax power. And so as long as they're just taxing you for not having insurance, that's fine. There was a big, huge conservative backlash against that. The Republicans in Congress, their response was they amended the law to zero out the individual mandate penalty. So now you are mandated to get insurance, but there's no penalty if you don't. And
It's actually a $0 penalty.
$0 penalty.
The penalty, they couldn't get rid of the penalty, but they could change the value.
Yes, I mean the mandate is there. There's just no dollar penalty to it. And so once they did that, now this is part of a strategy. Once they zeroed it out, then they re-challenged the law and said, if there's no dollar amount to it, then it can't be called a tax. There's nothing you're being taxed. And so if it's not a tax anymore, now the mandate is unconstitutional. It's just an unconstitutional order to get insurance. And if the mandate is unconstitutional, then the whole law, the whole program needs to be struck down. That was their new challenge. The state of Texas and a bunch of other conservative states, they brought this challenge. The Trump administration would not defend the law. They wouldn't defend ACA. So normally the federal government will protect federal statutes. They'll defend a federal statute in court. Trump organization says, no, we agree. We think the ACA is unconstitutional. It should be struck down. So California, the reason this case is California versus Texas, California and some other states intervened to defend the law because the federal government wouldn't. Texas, by the way, brought this case in Fort Worth. Judge Reed O'Connor. He is the go-to district judge anytime Texas wants to challenge anything they don't like. Any conservative cause in Texas, they'll take it to Judge O'Connor. Judge O'Connor struck down the ACA, said the entire law is unconstitutional, mandate's unconstitutional, the entire law is unconstitutional. Went to the Fifth Circuit. The Fifth Circuit basically agreed, but sent it down to reconsider one other piece of it. And then before it went back down to Judge O'Connor to be reconsidered, California and the other states that were trying to defend the law, they took it to the Supreme Court and said, you guys take a look at this because we think Judge O'Connor and the Fifth Circuit, they're all crazy.
That's the fastest way to get something. Right. 2 states. They can't not.
So
That,
so the question is that the fastest way to get a case to the Supreme Court if you have two states suing? That is typically true when you have a true case of two states suing each other, or one state suing another state. So for example, water rights, right? You get like Colorado and Wyoming arguing over a river, rights to a river water or something like that. That's going to have immediate jurisdiction at the Supreme Court. This is not that. What this is really is Texas suing the federal government to strike down the ACA, and then other states intervening because the federal government won't defend it. So it's not really, it's states against states, but not on a state versus state issue. It's actually a federal statute issue. So, but this is, because it's this case and the ACA, it was going to go to the Supreme Court was going to take this case. There was no question about that. So, but it didn't have to do with the fact that states were the parties. So the question here was first whether the mandate was unconstitutional, and then whether the whole ACA needed to be struck down, or could you just sever out the mandate and keep the rest of the law? And then this other question about standing was raised, because why does the state of Texas have standing? The state of Texas doesn't have to get insurance under the mandate. So why does the state of Texas have standing? Remember that standing doctrine we were talking about? So another question arose, do the plaintiffs here even have standing to challenge the ACA mandate? The Biden administration reversed positions from the Trump administration and said, actually, we don't think the law is unconstitutional. The court 7-2 says no standing. So standing cuts both ways, right? Standing is one of those doctrines where the court often uses standing to punt on things it doesn't want to have to deal with. If I don't want to have to address this issue, I'm going to say you couldn't really bring this issue to us because you don't have standing. The conservatives on the court have used that quite frequently to narrow the number of cases that can come to the court, but the liberals sometimes will join in on that to punt and avoid issues that are going to be sticky and hard to decide. So the upside here is the ACA survives, nothing happens, the challenge dies. The downside is we got another case that relies on standing and makes, we actually might have lots of other cases where we want states to be able to challenge a federal law, and we want the state to have standing to do that, right? But now we have another case saying states don't have that kind of standing to challenge a federal law. So that might be great. That we might like the outcome here, but in other cases we might not like that states don't have standing to do that, right? So ACA survives. That's probably the last ACA case we'll see, because I think the court has sort of made it clear, hey, we're not changing any more of this, right? We're done. We're sort of done hearing all this. All right, coming up next term, you guys might not be able to see this from back there, but Roe versus Wade is on the table. The court has granted a case about abortion rights. The question is, are all pre-viability prohibitions of abortion unconstitutional? In other words, can states start banning abortion pre-viability? A lot of questions. Everyone's going to be watching this case. A lot of questions about what the 6-justice conservative majority is going to do here. Are they going to just overturn Roe, or are they going to sort of death by 1,000 cuts, which is what they've been doing for the last 30 years? We'll see. It is the first case in quite a while. I think it's the first case in 25 years where it's just flat out asked the court to overturn Roe versus Wade. So it's a big case. Cummings is a civil rights case that asks whether or not a civil rights plaintiff can recover emotional damages for emotional distress. So we were talking earlier about, like, you might have a right that's violated, but you don't have any money damages, right? So if that's the case, you might be struggling to bring your case. Well, obviously, when you have rights violated, one of the harms you might suffer is the emotional distress, say racial discrimination, right, in the workforce. And you get discriminated against in the workplace constantly for months and months. And one of the harms that you suffer is the emotional distress of that. The question is, can you get damages for those kinds of things in those kinds of civil rights cases? And I think this one actually deals with mostly statutes protecting disabilities. and age discrimination. I don't think it actually addresses race discrimination in this case, but it's a big deal because if the conservatives on the court say, no, you can't get emotional distress damages for these kinds of cases, that's going to sap a lot of, take a lot of wind out of the sails of civil rights cases, right? It's hard to find attorneys who will take cases if you can't get any damages for them. And it's hard for people to be motivated to bring a case if they can't get any kind of recovery for it. I won't read through all of these, but another big one that's coming up is the Corlett case, which is a big Second Amendment gun rights case. New York has a law that doesn't allow concealed carry, and there's a challenge to that violates the Second Amendment. So what will the new conservative majority do with gun rights now that they've got a solid 6 to do what they want?
What is the end objective of the Supreme Court taking fewer cases? It's not to make themselves obsolete. Is it to free themselves up to overturn more things? Or, I mean, obviously they want to kick back more things to the states to decide, and that in turn empowers the federal district and appellate courts, right? But what is in it for them really by taking fewer cases?
So the question is, I look a lot nicer in the picture, right? So the question is, what's the point of taking fewer cases? And really the answer to that is it's a philosophical issue. So there's not like a strategic or tactical, if we take fewer cases, we can do this other thing kind of approach. It's really just philosophically the conservative side of the aisle, of the court at least, thinks the court should be the least important of the 3 branches.
And yet Republicans have spent all this time building up the court.
Because they recognize it's important. They think it should be the least important. Remember, the backlash for the Republican Party was against the Warren Court, which was doing a lot. The Warren Court was very active in protecting civil rights, desegregating the country, the Warren Court was taking a lot of cases and very actively doing a lot of stuff. And so the conservative side was like, this sucks. We don't want the court doing all this stuff. And we would rather have the court be less important. So they think the court is important because they want to have the right people on there for their side, but they think the court should be less active. So it's really just a philosophical approach. It should be the least important of the 3 branches, and deciding fewer cases is one way to do that. Also, if you get a good, strong conservative majority on the court, you can decide fewer cases and only decide the ones you want the way you want to, right? And that's the whole project.
Are there any constraints in the court asking a plaintiff to bring a different case, such as on the Farmers Branch case in the circuit? They said, why don't you bring in the SB 10 in Arizona and consider that as part of it? Or the Hillary film, famous thing.
Citizens United?
Yeah, where they said, why don't you come back with a much broader claim? And then the other is the Shelby County, where they said Congress really didn't mean to vote for that unanimously. I mean, those just seems like extraordinary overreach.
So the question is, I'm going to sort of summarize it if I'm getting it right. The question is, does anything prevent the court from basically telling plaintiffs or parties to do something different?
Yeah.
Bring it, telling Congress, hey, Congress, fix this. Shelby County is the big case where they struck down Section 5 of the Voting Rights Act and basically said, the way it is right now, it's unconstitutional. It's going to be fixed. Congress has to fix it. And Congress has failed to do that. So I think the answer to your question is nothing stops the court from doing pretty much whatever it wants to do. Congress can't, if the court, like with Shelby County, if the court says Section 5 as it is unconstitutional, Congress can respond and, update the Voting Rights Act and then you still have Section 5.
They did, they renewed it on the 25th anniversary.
Before Shelby County. That was before Shelby County. That was one of the arguments for why.
It was valid.
Yeah, one of the arguments for why it was valid is Congress just renewed this, right? They've already given their seal of approval, and the court still said no. The way it is right now, it's not good. But the short answer is the court can tell the parties whatever they want to tell them. They can say, you know, this claim's not good the way it is, but maybe if you come back later. And in fact, the court will do that. Individual justices will do that somewhat frequently. They will write a concurring opinion or a dissenting opinion. There was a case a couple years ago dealing with voting rights where Justice Kagan agreed with the court that so Democrats brought a challenge to gerrymandering, and the court used standing as a way to avoid resolving the gerrymandering question, and just said these parties don't have standing to bring this challenge for this gerrymandering. And Justice Kagan wrote a concurring opinion saying, I agree that these parties don't have standing, but if you wanted to have standing in order to bring this kind of case, here's what you would need to do, and here's the kind of person you would need to be in order to bring this kind of challenge to a gerrymandering. Justices will do that all the time. It's basically sort of like, you know, sending a signal to people, hey, do this, right? Or hey, bring this kind of case, and then maybe we could do what you want us to do.
There was something passed that set term limits for Supreme Court justices. Would it have to grandfather those current justices as lifetime appointments, or would it be made to apply to them too?
So the question is, if Congress passed term limits for the court, would it have to incorporate the justices currently sitting on the court? The answer to that is yes and no. So to get rid of lifetime appointment, you would have to amend the Constitution. But you can, there's nothing in the Constitution that says they have to be on the Supreme Court. It's the federal judicial appointment that is for life. So what you could do is pass legislation that says those sitting on the Supreme Court will sit for a term of 18 years. You could set up a system where every 2 years a justice is moved out and a new one's appointed, right? And that's your 9 justices. So every 18-year term, each justice gets an 18-year term. Every 2 years, a justice is replaced, and that works out to 9 justices over an 18-year term, right?
They move back to the circuit court.
Yeah, so then what you do with the justice who has served their 18-year term is they can then be reassigned to a circuit appellate court, or they could be given senior status, and they could sit in senior status on cases in, you know, a bunch of different situations. So you basically just are shuffling them around, so because you can't get rid of the lifetime appointment unless you amend the Constitution. But the answer to your question is, yeah, somehow you would have to write the legislation in a way that accounts for the people who are already there, because you can't really just remove them. Any other questions?
Jason, you're awesome.
Okay. Thank you very much for having me. Have a good night.
Thank you so much. So much. It's always so great when you come to Jason. It's so interesting.
Thank
and, helps us understand. And thank you again. And I'm going to just introduce Derek Gay, who's running for U.S. House 24. He's with us tonight. You got a few words, Derek?
Sure.
You can use the mic if you want. Be on Zoom.
Hello, I saw some of you at the last meeting, but I'm Derek Gay, and I'm running for Texas 24 to replace Beth Van Dyne. Just wanted to say a little bit about who I am and and why I'm running. But I'm originally from a very blue-collar union household, and when our country was attacked on September 11th, I stepped up and served my country and joined the Marine Corps. So I joined on an ROTC scholarship, became the first in my family to graduate from college. And after graduation, I deployed to Iraq. I was looking for roadside bombs. That was the #1 killer troops in Iraq and Afghanistan. Came back from that deployment, went throughout Asia with the F-18 fighter jet squadron,
and also worked with the Department of State. And then finished up my time on active duty at Parris Island, South Carolina, where they do Marine Corps boot camp. Got out of the Marines to attend law and business school at Northwestern, stayed in the reserves, was able to activate for Hurricane Harvey relief. And with the pandemic as well, I joined the Medical Reserve Corps. So my narrative that I'm trying to put out there is that at every point when my country needed me to step up, I stepped up for my country. And as you saw on January 6th, when her country needed her, when she had an opportunity to unite the country and do what was right, Beth Van Dyne failed to meet that moment. So she doubled down on a partisan lie, and she didn't follow her oath to the Constitution. So that is why I'm in this race, because I'm running to uphold that oath that I took as a Marine. I'm running to uphold that oath again. And, as we've seen, she's continued to not be there when we need her for the American Rescue Plan, for bipartisan infrastructure. She has not showed up and done her job. So that's why I'm running to replace her. And I hope to earn your trust and support in the coming months. Thank you.
Have you run for any elected office?
I have not. My prior experience in the Democratic Party was as a precinct chair. This is the first elected office.
Thank you, everyone, for coming. Thank you, everyone, for coming, and again next month. Okay, thank you very much, and have a good evening and be safe. Thanks all of you for wearing masks. Take care.